and it's on the wild horse issue. It's such a conundrum. Do any of you have any advice for us on how we should be dealing with the wild horse issue? Mr. Dahl, I also have a question for you about how, in your county, you're a county commissioner, Elko County, do you have wild horses? And if Nevada's, yeah, I suspected as much. So I would like some comments on this from you as well.
We do. We have a lot of wild horses. Our Nevada Association of Counties has filed suit asking the court to require the BLM to follow the act as amended and to sell excess horses at auction without limit. And we are just stumbling along trying to get that to win on that suit. But if I could, I would like to go back to Congressman Bishop's question about the value of the AUMs and tell you a little bit about what I am seeing happening in Nevada in particular. Generally, when cattle prices get as high as they are now, there gets to be more competition for ranches. And the ranch brokers, the real estate people, and so on all benefit from that. And what we're seeing now is that isn't happening, because the value of the AUM is, you just don't know what it is. And if I were to go buy a range permit right now, I would be looking for winter country that has no live water on it, and where you haul all of the water or pump it. Because if you have riparian areas, then, for instance, on a ranch that I used to own that now is in northern Dixie Valley, where the rancher who is there now went to turn his cattle out this spring, BLM went to him and said that we want you to take a voluntary non-use of this area because the stubble height in the riparian areas is at 4 inches. He said, I haven't turned any cattle in there, and they said, I know, but the horses have eaten it. The horses have got it down to 4 inches, and so, and I don't know how many of you followed the Pete Tamara Ranch and the problems that we've had in the Battle Mountain area. We've had a number of tours out there where the grass, we had a picture in the newspaper of someone who showed that the grass on the average in the uplands was 21 inches tall, and they were moved off because of the stubble height on the riparian areas. So then the proposal was, we'll fence the riparian areas, and a whole bunch of us just got together and said, well, we'll go down and we'll help them, and no way, we're not able to do that. But there's another interesting aspect to this. Last fall, there just got to be a lot of discussion about what's really going on out there, and just kind of spontaneously a bunch of ranchers met in Winnemucca. Fortunately, we had Mark Amadei come and meet with us and started telling what's happening to them. You know, they're BLM coming to you 1 week before you turn your cattle on your winter range and say, we're going to cut you 50%. You know, what are you going to do? So Mark Amadei, bless his heart, he said, you send me letters and tell me your stories, and I'm going to do something with them. I don't know, a congressional, maybe like a field hearing like this. And he didn't get any well, he got a few letters, but hardly any letters. And I knew the people that were there were a bunch of them. And I started calling them, and some of the others who knew them started calling them. Why don't you send in the letters? And they said, we don't dare. We don't dare. Because of the repercussions. And if things get really bad, we're going to have to sell out. And if we've got BLM telling us, okay, you can turn out, and then come in 2 weeks later and say, now you got 5 days to move off because you've hit your triggers. We don't want people to know that about our outfit. We might have to sell it. And in a meeting I had last February with Neil Cornsey, the National BLM Director, I said, we have a huge intimidation factor out there. And boy, he just bristled, because he says, I'll have you know it's against the law for a federal employee to intimidate. And I said, it's systemic. It's built into the system. It's not, I'm not saying you have a, and we've got a lot of good people in the agencies, you know. But just the power that they have over those people's lives, and those ranchers, it's not like they're working for GM and they can leave and go work for Dodge or something, you know. I mean, this is their life. This is what they do, and they can't just up and leave. And it has gotten really, really serious.
Let me also add a little bit of perspective on the wild horse situation, because I'm the attorney litigating the wild horse case in Utah, where we have a federal court now who is allowing a case to go forward. I represent 15 ranchers who have requested that BLM remove excess wild horses from private land as well as state and federal land. We now have the administrative record for that case. The wild horse groups intervened in the litigation, even though we fought that. They were allowed to intervene anyway. They are arguing that it is all totally at the discretion of the agency, and they are threatening additional NEPA litigation, not over the substance of whether the horses ought to be moved, but they are litigating and bringing into the issue process. If the BLM is going to remove horses, they got to jump through 97 procedural hoops, and if they miss one I or one T, then the environmental group, wild horse groups, are going to stop their movement. And BLM has told us as part of the litigation that part of the reason they have not removed these wild horses from private and federal land, even though they are required to do it by the Wild Horse and Burro Act, is because of excess litigation by wild horse advocacy groups stopping BLM because they can't seem to get through the NEPA process. One of the other frustrating things we found in this administrative record is that the BLM has actually created contracts and done all sorts of things to find additional holding areas, to get additional gather methods to try to get these horses gathered up, but they can't implement them again because of litigation paid for by these folks and my tax dollars that stop the agency from making decisions. And so we are now in the middle of federal court litigation to try to get these horses removed. Wild Horse and Burro Act specifically says that excess horses shall be removed. The excess is described in land use planning processes. So when the agency goes through land use planning, which is a full public process, completely compliant with NEPA, they set a maximum number of wild horses that they believe the land can ecologically sustain, along with livestock, along with wildlife, along with all of the other things that protect our public lands. So the BLM sets these numbers, but every time they try to remove horses because the number of horses are too high, they get sued by environmental groups. And if you look through the Federal Register and if you look through the litigation, these groups they file an injunction because the BLM can't get through the NEPA process, they win, and our tax dollars pay for it. And that's why, they will tell you, that's why wild horses are not being removed from the federal land, to the detriment of the land as well as the ranchers, as well as these rural communities.
Can I tell you something about wild horse?
Do you know what KB stands for? The BLM gathered a bunch of horses at Eureka in Nevada, and they took them to Palomino Valley, and they sorted through them, and then they were going to bring half of them back. They gathered 400 horses. They were going to bring 200 of them back and turn them back out on the springs that were beat out. And anyway, so the ranchers got together and sued to keep them from being able to bring the horses back. Went to Interior Board of Land Appeals. The ranchers lost. So the BLM brought the horses back, and where they usually brand them under the mane with numbers and, you know, whatever that means, they came back with a big KB on the left stifle, on the where you could see it, iron this big. And the wild horse specialist who was heading up bringing them back says that stands for kick butt, because that's what we did to the ranchers in that lawsuit. That's what we've got going on out there. It's just incredible. Just incredible.
Well, I want to thank our witnesses. I want to thank the staff of the Oversight and Government Reform Committee. Would you three please stand and be acknowledged? Thank you. Chairman Bishop, would you introduce your staffers who are with you today?
I think I have two from my personal staff who are here, so if they would just stand, or just wave. Wave, you got it, okay.
And from our in-state staff in the Wyoming office, Pat Allman, would you stand? And from our Washington, D.C. office, from Casper, Wyoming, Jimmy Ward. Richard, you are acknowledged for just a final remark.
I just have, would you bring us up to date, please, on the situation with the wolves being taken off the endangered list of the bill itself?
Yes. Representative Bishop made one of the savviest moves that I have seen a member of Congress make while I've been there. He is on, of course, chairman of the House Natural Resources Committee, where all the wolf work is being done. But he's also on the House Armed Services Committee. And the House Armed Services Committee's annual bill is a must-pass piece of legislation because it authorizes the annual activities of the United States Department of Defense and the U.S. military. In crafting that bill, he was successful in the House Armed Services Committee in submitting a amendment on the sage grouse specifically that was adopted and that passed the House, and when that passed, people from the southern states, especially Texas and Oklahoma, said, well, if they can use the House Armed Services Committee bill to get a sage grouse limitation amendment, let's try one for the lesser prairie chicken. And it was successful. So in doing so, I think Rob was able to break through a logjam that a number of us have found on other species. Now, with regard to the wolf, we've not been as successful. We had a really great amendment on the appropriations bill on the Interior and Environment. So these are all of the agencies under Interior, the Forest Service, and the EPA. It had been 5 years since that bill had been on the floor of the House because it's so controversial, and both parties try to amend it so much it chews up so much floor time that leadership doesn't have time to put it on the floor and accomplish the work necessary. So we finally talked him into bringing it to the floor. It was a fabulous bill. We had an amendment on there that would overturn the court ruling that affected Wyoming wolves and the wolves in the Great Lakes, both of whom had been delisted, but a court in D.C. subsequently threw out the U.S. Fish and Wildlife Service's delisting rule, thereby requiring that they be once again listed. And that legislation was moving through the House successfully. Then, a member from California was successful in attaching an amendment to the Interior Environment Bill prohibiting the display of the Confederate flag even in Confederate graveyards. And it sunk the whole bill. So all that good work went down the drain with one non-germane, I would argue, amendment. For now, we are seeking other courses of action. Do you have any additions?
Yeah, this is one of those things that becomes a conundrum, because we've been talking about regulations and all the rules and how bad they are. This is one of the few times where you actually are happy with it, because the court overturned a rule of the Department of Interior that delisted the wolves in the Great Lakes in Wyoming. So this is one of the times that it was kind of unique, because we'd say, okay, this time we want to defend the administration and what they're doing. And it was very difficult for those who are usually opposed to those efforts to fight back on that. Now, for those of us in Utah who are not covered by that rule, we got screwed. And we have to do something else. And she is right in the process. If you see that the House and Senate has a continuing resolution, that language will definitely not be in a continuing resolution. We'll have to wait to fight it next year. If we do an omnibus appropriation bill, and there's 50-50 chance that can be worked out, that kind of language could actually be included in that. And if we can go through our appropriations process, and that's looking pretty scary right now, because not only is the House not finished with ours, but the Senate hasn't even begun it. That's going to be, this avenue of approach is going to be difficult to do. The good news is, I think whether it's done this year in approps or next year in any kind of standalone bill, the momentum is on the side of us in the delisting concept, because it's logical, it's been upheld by the agency, it's just one rogue judge that tried to reverse it, and I think you have had several votes to maintain it in different venues. So one way or another, I think we're eventually going to win on that one. Now, for those of us in the Northwest and in Utah and down the deals with the Southwest, we're going to have a more difficult road to hoe because we have not been delisted in the first place. But we're not going to give up on that issue.